Thank you. Good morning. It's a couple minutes after 9 a.m. on Wednesday, February 25, 2026. This is the continuation of the hearing in the Lakefront Park improvements. Just very quickly for the record, the file numbers of the application components are they all end with a 3 zeros and a 1, so I'll shorten them and say, and they all, well, let me do it this way. They all start with 2025. They all end with 0001, so I'll just tell you what's in the middle. The applications are an SSD, an SCUP, an SVAR, a ZCUP, and an ADAP, ADAP. We are here this morning primarily to see if the idea of continuing starting with the 10th of March is going to work for everybody. And the parties weren't sure yesterday whether that would be the case. And so we said, let's get together tomorrow and we'll figure it out. Let me ask the appellant's attorney, Mr. Haneker, is that week going to work for you folks?
Mr. Hearing Examiner, I actually reviewed the rules again this morning, and I noticed that Rule 216A, in the case of a postponement, sorry about that, for the submittal of additional submittals is to be for not less than 3 weeks. And one of my experts is not even available for 3 weeks. And frankly, I don't know what's in what the city is producing. So we may need to retain different experts additionally. So I would just ask that we go by that rule.
Clarification of Rule 216A. It deals with the situation where an applicant submits plans and proposals directly relating to their project. In other words, where they change the darn project less than 15 days before the hearing. In that case, a postponement shall normally be for not less than 3 weeks. I don't believe that's the reason we're postponing it today or continuing it today in the first place. In the second place, it says normally, which is a weasel word, if you will. Doesn't say it has to be 15 days. So I'm not worried about complying with Rule 216. It either doesn't apply or it has flexibility.
And so, I mean, to give a direct answer to your question, your previous question, my clients are available that week. One of them is a doctor, and so she has trouble getting time off, but she is available on that Wednesday and Friday, I believe. And possibly, so the Wednesday and the Friday, I believe, as well as maybe the Thursday. So yes, so the short answer is for clients, yes, as long as Miss or Dr. Fudge goes on a certain day, that will work for her. One of my experts that I have currently is available that week. The other one is not available that week, though she is available the next week. And so, okay. And yesterday I mentioned that there was some allowance given to the city for a potentially out of order witness. And I've actually found that it was in your initial order after our pre-hearing conference that was allowed. And so I would just ask the same be allowed for my witness.
Absolutely. Not a problem. Um,
And
as long as we're not asking for 2 or 3 months from now.
no, no, yeah, it would just be
Okay.
the date. And I would like to say just one more thing is that's all contingent on the city being able to get its new documents to the hearing examiner and the parties, as well as the documents entered into the record yesterday, as new exhibits to us by 5 o'clock today.
Okay. We'll find out about that in just a minute. So at this point, we're at least a hope for go for starting on the 10th to finish this out. Ms. Pratt, how about the city's availability?
I have the city is available that week. I would like to address the additional exhibits that the hearing examiner requested yesterday that are listed on the index and how we can provide those and really why they weren't provided in the first place. You know, we're happy to provide almost all of these requested sheets. There's only one that doesn't exist right now. It's sheet 68. It has not been produced and would be prepared in the future for a building permit submittal. That said, the newly provided sheets were purposefully omitted from the various land use permit applications as they were not deemed necessary for land use review decisions. So while it's reasonable that these sheets become part of the record, if you want them, Mr. Hearing Examiner, their omissions were not a factor in the city's permit recommendations, and we don't think they should delay the hearing. I have a chart that we worked on. I'm not sure when people slept last night, but I have a chart that shows the examiner for each of the exhibits that I'll note more than 3/4 of them would not be submitted until 100% design and ministerial permit applications are made. And Mr. Hoffman, the CPD director, would like to be able to address that with you, Mr. Examiner.
Okay. Let's settle the date first.
But sir, if these were not needed for the city's recommendations, I am opposed to a continuance of this long.
Okay. Mr. Hoffman, would you raise your right hand, please? Do you swear or affirm that the testimony you'll be offering in this hearing will be the truth, the whole truth, and nothing but the truth?
I do, sir.
Thank you. Would you state your name and spell it for the record?
Thank you. My full name is Mark Hoffman. First name is spelled M-A-R-K. Last name is spelled H-O-F-M-A-N.
Thank you, Mr. Hoffman. Ms. Pratt, do you want to just let him speak, or are you planning with a Q&A?
I'm just going to let him speak. And Mark, if you'd like me to bring up that chart, I'm happy to do that.
I thank you. It's a variety of things. I'll just start with continuing what Attorney Pratt mentioned. At the beginning of the hearing and the testimony, and again today, it was mentioned which local permits are being sought. They've been listed. Then yesterday, the cover sheet of Exhibit 1 caused confusion or this issue. And the intent of that has been clarified. That is for later permits. The accounting that we did last night was for what's already in the record in the exhibits that may not be included in Exhibit 1. And so everything that we relied on are in the exhibits. We have the sheet numbers. To address the first issue, these land use shoreline permits are a type 1. The appeal rises to a type 1. That's what's before you. The record is complete. The issue about what's listed on the cover sheet right now that would go into ministerial permits later is not missing information. I could show you in code why that basis can be determined. A type 1, 2, or 3 is gathered together for the hearing examiner for one review, one hearing, and one decision. The ministerial permits are not part of that record, nor review, nor decision. In our code, it differentiates ministerial administrative actions or decisions. Those are listed. That includes building permits, clear and grade permits, tree permits, right-of-way permits, things like temporary erosion, sediment control, etc. Those are later in the process and will be based on an action by the hearing examiner in these type ones. So I have the code section, and what's clear is that these ministerial administrative permit applications are not required at this time. The legend on the cover sheet lists 114 or 150 sheets that are intended to be a tool for that purpose. The exhibit sheets in our SEPA documents and the hearing documents contain the sheets that are relevant to the type 1 and the appeal.
Are you, well, let me give an example and see if I'm way off the mark here. Take a preliminary subdivision application, and let's say it's on very hilly property. Are you indicating to me that no information regarding potential grading of that site to accommodate the houses and the street layout that's being proposed is at all relevant in the preliminary subdivision review stage because grading plans are administrative?
No, sir.
Okay, good, because I would have a real problem if you said that.
The ministerial admin permits that come later are administrative. And for summary, they're intended to show consistency with the prior permits.
But I would suggest, and my experience in every jurisdiction, including Lake Forest Park, which doesn't have many subdivisions to ever deal with, at least not in my tenure, is that there is always a preliminary grading plan
Yes, and
submitted
that is
with the application, because otherwise the reviewer has no idea whether mass grading is going to occur or just a little bit of grading, whether they're going to work with the terrain or whether the developer has the theory that, well, we'll cut the hillside in half and we'll have a 20-foot retaining wall on one side and a 20-foot fill wall on the other side, and we'll have flat lots. You don't know that unless you have some preliminary grading plan submitted. And in my experience, every city has always done that.
yes, and we do as well. The existing conditions information and the site grading, the stormwater lens, all of those reviews, the sensitive area, that information is in the record, was on the website with the public hearing notice and is available. The sheets listed on Exhibit 1 cover sheet are not intended to be that. Those titles that you reviewed that says grading plan are a later document. The contents and the sheets that we could demonstrate are in the record right now do show that grading information. They do show existing impervious surfaces. They do show proposed. They're just not the same sheet title and letter as Exhibit 1 cover sheet.
It makes it a little hard for the hearing examiner to approve a set of plans for the substantial development permit, the CUP, the shoreline CUP, the shoreline variance, when you're indicating, I can't just say Exhibit 1 is approved, because you're telling me there's all kinds of stuff on there that really doesn't pertain at this level.
Exactly. And so the draft conditions in the staff report include a condition that right now I believe says, as demonstrated in Exhibit 1. That can be modified. So whatever sheets that we have in the critical area report, the biological evaluation, the application submittals that you rely on can be added to that draft condition of approval in your action and that would represent documents that are in the record that you would rely on.
Hmm.
We're asking you not to just rely on Exhibit 1.
So I have to go through all the documents and pick exhibits that I think represent what you folks want me to approve as the project plans and then reference them.
And we could assist with that. They're all there. For instance, in the critical area report, there are 5 sheets that do not appear on Exhibit 1. We are requesting that you take those into account, and if you take an action, base it on those. So with the final condition of approval would list those. Those are available. They're in the exhibit. We could demonstrate those. What may be helpful is a draft condition that represents all the sheets that are in the various reports. There's a lot of material throughout the entire record. Not all of that is pulled into Exhibit 1, but they're clearly labeled and they're clearly included both at the SEPA review timing and the hearing timing. I can point out, by way of example, the critical area report. I believe it contains 5 to 6, 7 specific exhibits. That was available. That was made available to the consultant for the appellants. That's listed as a reference in their document. They're all properly labeled. We relied them on them for our review. We're asking you to rely on them for your review and decision. If there's a way to better organize a list of what all exhibits are in the record that represent sheets and plan numbers, we can do that. But the first issue was the 150 or so listed on the cover letter of Exhibit 1 are not intended to be the record for this Type 1. We're clarifying that that list is a working document towards the 100% design and the ministerial building permits. All of our sheets are distributed throughout the reports and available, and we hope that you review them.
I will admit that I totally misunderstood or misinterpreted the city's intent with Exhibit 1. I believed that was the set of plans that the city wanted me to approve in approving this bundle of 4 applications. I didn't realize that you wanted me to go through individual documents in the record and find plan things and be the initial person to say, this page out of this report is the proposed plan for shoreline variances, or shows the shoreline variances and what we want with them. And this page in another report is the plan for shoreline CUP improvements, et cetera. I did not interpret it that way because that's not the way I'm used to seeing things come in. Ms. Pratt wants to jump in.
Mr. Examiner, we would have had and will have our witnesses go through those. We did not intend for you to do that without witness testimony that explained which exhibits, in where they are and what they were needed for. But we did not even get through one witness yesterday. So that was not provided to you yesterday with one witness.
Okay.
Mr. Galt, or Mr. Hearing
Mr.
Examiner.
Raniker.
Yes, thank you. I'd like to point out, we didn't even get through one witness, and we already discovered how messy, how lacking this application is, Mr. Hearing Examiner. The question isn't whether or not they had exactly the right drawings. The question is whether or not you have enough information in order to grant these permits. And I trust that you already read the information that was given to you by the parties. I know I have. And you said yesterday that there was not enough information to make your determination and that you wanted a number of sheets. And now the city has said they have most of them. They've said one of them just doesn't exist. And even if some of those sheets were somehow intended later for a ministerial decision, that ministerial, you still need information related to that ministerial decision, as Mr. Hoffman said, so that later there can be compliance with your order now on that ministerial decision. This is the city's burden to prove to you that it did this right. And in fact, the city's code administrator should have reviewed all of this and transferred its entire record to you. That's Lake Forest Park Municipal Code 1626080A. And it hasn't done that because either the city did not review everything or they didn't transfer you the entire record. And it's not your job to hunt through the morass and try to make the city's arguments for it as to why this meets the standards that you're required to apply. Furthermore, if you were to grant this, I would say that it's in violation of the Shoreline Master Program requirements that variances, the SFAR in particular, cannot be granted as a special privilege enjoyed by other properties in the area. I don't think the city is going to grant this to anyone else and move it onto your desk in the condition that it's in. This is essentially an incomplete application because it is not clear from the record that's before you why, and you said so yourself, why this permit should be granted. So I would actually like to reopen my request that the hearing examiner deny or remand the permits at this time to the city to put together a new application. Or at bare minimum, give the applicants time to go, or the fudges the time to go through it that we talked about yesterday. You know, I know my experts who I mentioned before will testify that they were unable to find a clear drawing of the current site conditions. Now the city seems to think that it's buried somewhere in another drawing, maybe overlapped with other things, but that is not sufficient evidence on which to base your decision. And so I made my request and I stand by it that the permits are denied, remanded, or at the very least, the hearing is continued.
Okay, thank you all. Your motion that I remand or deny at this point is not approved. I would at this point characterize it as a suggestion from Ms. Pratt that we march on today as if none of this discussion had occurred, in the sense that we'll just keep on trucking with our regular schedule this week. I don't think that is appropriate either, because we indicated at the time pretty clearly yesterday afternoon that we were at a problem point and we needed some time to fix it. So I think continuing on with testimony today is not appropriate. I understand what the city is saying. I'm not sure that I buy all of it as being an appropriate way to do this. As I was thinking yesterday after we adjourned, I'm thinking, okay, and this was before I realized that the city intended for me to go to all these other supporting reports and pull things from them to create a set of plans for what it is that they want approved. I was wondering, would the city do it this way for a private party? would they seemingly on the surface defer everything and expect the examiner to approve something that says um, for grading, one of your conditions is you got to get a grading permit without having shown any preliminary concept of what kind of grading I would be approving, as I gave in my example a couple of minutes ago. Could be minor grading. It could be a wholesale revision of half the world. And I don't think I've ever done that. And I don't think I'm ever intending to do that. Uh, if I'm approving something and deferring action to ministerial permits that are to follow, I believe at the quasi judicial level, there needs to be guidance given as to the scope of what those ministerial permits can do. Otherwise, why in heck have a quasi judicial hearing at all? Why involve us in all of this if it's just totally being left open ended? And I think I understand now, particularly from Mr. Hoffman's testimony, that that's not their intent here at all. But it's the way that I perceived it as I looked at the materials and how it was coming out. I am not willing to continue today, but I am willing to go back tomorrow morning to pick up where we left off yesterday. If we want to take the time this morning, and it might be a beneficial thing to get this chart or table or whatever it is that the staff has put together about these plans and where they are and what have you. I'd love to take our time to do that. But because of the tenor of the proceedings at the time we stopped yesterday, I'm afraid that most lay people, and when I look at the, where's the participants list?
Yeah, Mr. Hearing Examiner, I've heard from my client that he's actually already scheduled things for the next couple of days, and neighbors have, and communicated to neighbors who I'm sure have made their own plans in reliance on what we went over yesterday.
We did not decide that there would be a 2-week continuance yesterday. If Mr. Fudge, as the appellant, has now made plans not to be available, that was a mistake.
I believe it was pretty clear that there would be a significant continuance, even if it was not. Well, we can review the record.
It was clear. It was not a promise. It was a strong implication that it would be a reasonably lengthy continuance. I have not gone back and listened to the recording, obviously, but I think part of that was due to the city saying, hey, we need some time to do this. We don't even know what these things are that you're talking about. We can't just pop these exhibits back up for you.
And so I asked to be here this morning.
Mm-hmm. Yeah, and we are here. I want to hear about the list. I want to, if it's in admissible form at this point, I would like to have it entered so we've all got it. I will take testimony on the intent of the city in its relationship among all these plans and documents and what have you. But then, and I expect that's only half a day would be my guess, if that. And I
Mr.
think
Hearing Examiner, I don't believe I actually finished my cross-examination of Miss
that's
Lisa.
correct. You did not. So we can start with that if you want. Um,
Tomorrow is what you're saying.
well,
Only tomorrow.
I wouldn't mind finishing the cross-examination of Ms. McCulloch today. Um, I'm
After-
trying to make this work for everybody, but at a certain point, I will just plain do what I think is right and let the chips fall where they may. But if we can't reach an amicable view on this, then I'll put my foot down and we'll do it my way. I don't like that, but there are times when the examiner has to make a decision and just plain say, we're doing it this way. As you can tell, I'm trying to see if I can find a amicable solution that will make the parties, if not happy, at least not mad. There is perhaps a subtle but important difference between being not happy and mad. It's that middle ground that I think I strive for in issues like this. Because my reason for saying let's not go on full board today is that folks who were with us until we broke yesterday would at least be under the impression that we weren't going to have a substantive proceeding today. I think that's pretty clear from what was said yesterday. I would agree with Ms. Pratt. There was no commitment to how long the break would be. There was discussion of various amounts of time and what have you, but I did not make a promise to anybody as to how long the gap would be between yesterday and when we continued with the substantive part of the hearing. So to the extent that I implicated a couple of minutes ago that I would be willing to let Mr. Aneker finish his cross-examination of Ms. McCulloch, I'm going to withdraw that. I'm going to hold that until the first time that we get back into normal order, if you will. I want to get this document, paper, list, whatever it is that the city indicates they have prepared. I want that in the record, and I want to have that discussion this morning. I have, as I was preparing for the hearing, written down a bunch of questions that as we go along, if somebody answers them through their testimony, I check it off that that one's been answered. And when we get through the direct testimony, if there are any that haven't been asked and answered by one or more of the parties, then I start asking those questions. I think it would be worthwhile for me to just read my questions and not ask for answers, not even accept voluntary answers today, but just this would be a list of the concerns, the things that I didn't quite get as I was reading the materials. And it's sort of an advance notice that, hey, if we can talk about these as you present your testimony, that's great. If you don't, you can expect the examiner is going to ask you about it. But if I lay them out on the table today, then you've got at least probably a day or two to think about them. And that's better than me just popping them at you stone cold later on in the proceeding. I want to do that. That shouldn't take us very many minutes. And I was planning at the end of this morning's session to simply make the observation to all the parties that in my experience, the hearing process is not a very good process for trying to reach a mutual settlement or mutual agreement that's good for everybody. That's mediation. That's where mediation can shine. Or just even settlement discussions if one does not want to get into strict mediation. In a hearing, the hearing officer is not trying to make everybody happy. The hearing officer is trying to figure out what does the law require and what do the facts show, and then put them together and issue a decision. And sometimes it makes one side happy and the other not. Sometimes a decision can make both sides somewhat unhappy or both sides somewhat happy. But the goal in a quasi-judicial hearing, I believe, is to look for that meeting of the application of the law strictly applied to the facts that are presented in the hearing. There can be settlements that maybe wouldn't fit that rigid test, but yet would be approvable. And I've seen cases where an applicant and the city have gone out during the hearing and had some kind of discussions and chats and come back in and said, we want to suggest this as a solution to our disagreement, or where neighbors have done the same with an applicant and found a way that everybody is happier with and have come back into the hearing process and said, you know, we want you to consider this because if this can fit into the law, this is what we'd all like to see happen. And I would only suggest that I have the impression that while there has been apparently a lot of public involvement on a large grain scale, if you will, there doesn't seem to have been much, if any, direct discussion / negotiation settlement talk between our appellants today and the city. It seems from what I heard yesterday, have been involved in general beach road meetings and things like that, but it didn't sound like there had been a one-on-one of, okay, what's your problem? Is there anything we can do to help solve it? So I was going to conclude by just saying, to the extent that either party wants to get involved in something like that, I would encourage it. I am never disappointed when an appeal goes away because the parties have found a solution that makes them both happy. Now, I apologize, Mr. Hoffman, but I'm going to ignore your hand for the moment. That was just going to be a parting suggestion to the parties that if there's any room for that to happen, be my guest. Now, let's figure out, let me do the questions first. Let's get stuff done that we know we can get done. I've got about, well, I don't know, 17 or so questions here. They are in no order. They're only in the order that they occurred to me as I was reading documents. And I will tell you, I did not read all the documents in order. So if some of these questions seem to jump around from one topic to another, it may be because I was jumping around in the order that I was reading stuff. I'll give you question numbers. There'll be some that I will skip, and that's because they've been answered already. But to keep my paperwork and yours matching mine, if you want to refer to questions by numbers, I will go with the numbers I originally wrote down. Number one, what's the approximate height of the Fudge's flat roof on which their solar array is located? I can't even read my own writing. Number two, why is Facet listed as the applicant? Facet's a consultant. I don't see Facet as an applicant, so that confused me a little bit. Number three, let me rephrase this. Were formal applications for S-CUP and SVAR filed? I did not see them. The SSD application has a place where they could have been checked. They were not checked. And the items that are listed as SVAR and S-CUP applications aren't. They're narratives about those applications, but they're not an actual application form. It's a technical point, but I just want to know if such things exist. Number six, why, and this is going to the exhibit thing, why are the building plans, like the elevations, not shown in Exhibit 1, but they are in Exhibit 12? And that I think I have a better understanding of that right now. Number seven, in the 16 of the traffic study, isn't it? Yeah. In Exhibit 16 on pages 8, 14, and 15, those are diagrams, and the numbers that they are diagrams of turning movement counts at various intersections. And for each movement, there are two numbers. A number that's just sits there as a number and a number that's in parentheses. And I looked and looked and looked, and maybe it's on the pages, but I could not find a key that tells me what the bare bones numbers are as opposed to the numbers in parents. I can make a guess, but I don't want to run my life based on a guess. Number 8 is a general thing I was going to ask, and this may come out in the testimony anyway, to discuss the parking calculations and the code requirement. It seems that pretty much everybody agrees that on the surface of it, at least, the number of parking spaces proposed on site doesn't meet a code requirement. And I really want that developed and explained. Number 9 is the reciprocal parking easement in Exhibit 18. The language of that, I was reading that to try and understand what it actually does. If I'm reading it correctly, it's an agreement between the owner of the shopping center parking area and the city. And it seems that it limits the city's use of parking spaces to those persons who are actually using city hall property. If I read it carefully, I think that's what it says, and I'm not quite sure how that applies to us. Number 10, you answered yesterday, so I'll skip it. Let's see, number 11. Exhibit 31, which is one of the comments received during the SEPA comment period. This is Exhibit 31 at PDF pages 9 and 10. Refers to a sewer pump station to be located on the park property. I didn't see any reference to that or any provisions for space for that in the plan, at least not that were intuitively obvious. And it struck me that if I'm approving a project plan and people know that there's going to be a sewer pump station put on it, that's part of the use of land, and maybe that should be shown. So I was a little curious about that. Number 12, I think I know the answer to this. In fact, I'm quite sure I do, but I want to ask one of you folks. Is Urban Conservancy a zoning category? There was one or more comments that seemed to suggest that the writer of the comment was convinced that Urban Conservancy was a type of city zoning category. And I just want that clear one way or the other. Number 13, the basic question says, what exhibit delineates the wetlands and their buffers and the stream and its buffers? And I noted then afterwards that exhibit 11 at PDF page 16 shows the delineations, but it didn't seem to show buffers that I could see. So I was a little confused. We're putting fencing around things. Usually the fencing, in my experience, has been around the outer edge of the buffer, not just the outer edge of the wetland. And I'm not clear in this case if that's what's happening or not. Number 14. The issued HPA, that's Exhibit 37, appears to allow solid deck sections in the center of each run, each segment of the dock, or of the pier, whichever you want to call it. And so if the city is proposing to use what appears to be an ability under the HPA to have center sections that are solid as opposed to graded, are the coverage numbers that are used in the materials that talk about the grading of the decking, providing more light transmission than the existing wood decks do. Do those numbers account for solid sections in the middle of the new deck, if they're even going to be used? I don't know. Couldn't figure that out. Number 15, are shoreline administrator determinations binding on the hearing examiner within the context of a quasi-judicial hearing? Number 16, a real simple one, I hope, is the 2013 Shoreline Master Program the most recent version of the city's SMP? And again, I think I know the answer to that, but I want one of you to be able to tell me about it. Number 17. I was looking for how the city handled certain SEPA procedural matters. And so I went to City Code Section 16.04, and 16.04.040 through 16.04.190 all say that for this particular subject, whatever it happens to be, we adopt WAC 197-806- and then some section number. And I thought, okay, a lot of cities do that. Not a problem. 197-806 is, or was, DOE's model shoreline regulations that jurisdictions could pick up and use in whole or play games, amend it and what have you to fit their own needs. But when I went to the online WAC, I discovered that WAC 197-806 is gone. Every section in it's been repealed. So every section that the city code refers to doesn't exist anymore. So I now want to know what is the city using for its SEPA procedural requirements and expectations. I think I mentioned this yesterday, but I don't think we had any testimony on it. It was a question that I had. So question number 18 has to do with the distance between the ordinary high water mark and the first pile bent on the new pier. And if I recall correctly, yesterday I said something to the effect of that my experience has been with docks on lakes that the first pile bent was always 18 or more feet from the ordinary high water mark. And if I recall correctly, the cities were requiring that because that's what fisheries said they had to do to get an HPA. And so my question was simply going to be, is the first pile bent here subject to that requirement? And if it is, does the proposed dock provide that separation, that distance? And then the last one, number 21, I'm skipping 19 and 20 because they've been answered. This again goes to the plans. Why are the site demo plans and building elevations in the biological assessment? That's Exhibit 12 at PDF pages 63 to 71, but not in the site plan set. And again, that's the whole thing about what's in the plans that I'm supposed to be reviewing. So now, let's hear from the city and get that document or documents in that help me understand the plans and that good stuff. Ms. Pratt, do you want to take the lead on getting that going, that discussion going?
Yes, I can do that. So I've shared the chart that was put together last night. I'm sharing my screen, and what it does, this column is a list of all of the sheet numbers that the hearing examiner asked for, and the plan number. Next column is the title. This is where we've shown it's included in another exhibit, which I think we fleshed out a bit previously this morning. And then these are the sheets that we can add, and the only one that we can't is 68. It is not done yet. And notes on the survey, for instance, it was submitted, and we can add it as a new one for the hearing examiner exhibits, where of course we can do that. And then these notes are all telling the hearing examiner that these actual sheets for this plan, for the plan set, when it would have been included as for these ministerial permits, and we've listed the permits where it would have been included. We are not saying that the hearing examiner doesn't have this information now, but this exact that you need for these particular land use permits, but that these actual sheets would not have been done at this point. They would have been included in the plan set for the ministerial permit applications. And so I can send this to you and Mr. Anaker, or do whatever. We can go through each of these today. It might be helpful to do that if you want to do that today. Go through each of these rows.
That would be fine with me. Let's first mark this and enter it as Exhibit 45. What would you have me title this? Plan sheet explanation chart,
sure.
or
Cover sheet.
okay. Cover sheet numbers explanations. And if you could have somebody down there at the city just email it to me, that would be fine.
And this is probably as good a time as any. I haven't seen exhibits 1 through 44 yet, or 41 through 44 yet transmitted, and I would ask that that comes at the same time. So as we're
Could
newly
the city
entered.
do that for Mr. Anaker?
Yes, we're planning on sending everything that was discussed yesterday. Did we do that last night? No.
Yeah. And I'm not surprised or upset at that. The normal thing that most cities do, at least that I'm aware of how they do it, is when the hearing is over, uh, they get these things onto their websites or send them to people. Usually they don't send them to individuals, but they put it on the website to augment what's already out there. But
And
where this is going to go on for a while, I think it's not unreasonable that
yeah,
we get them to them. So,
it's
and
fine.
Ms. Pratt said that they will. So
And
let's,
I would say exhibits 42 through 44, the city never intended to introduce those as exhibits to this hearing. The PowerPoint would have just been an illustrative exhibit. City isn't relying on those, that presentation to grant these permits. And the same with the photos that the examiner asked for later on, during testimony. The city didn't intend those as exhibits and would have just relied on them as illustrative exhibits.
well, we may have
Explanation.
a different view of what ought to be an exhibit as opposed to an illustrative exhibit. Um, for example, the seawall pictures, I did not find a clear indication in any of the plans that I looked at that showed the seawall. To me, the seawall pictures are more than just illustrative, just a picture of something that's on a plan. It showed me exactly what was there, which I was not able to see elsewise. So
Right.
be that as it may, they're exhibits, and if we can get them to Mr. Anaker, that would be great. And I think Ms. Pratt said that she can have that done, and so let's not belabor it.
Thank you.
Um, Mr. Anaker, do you want to have them go through and explain each of the lines on this chart?
To
Because
be
I'm
honest,
willing to wait and review it on my own time
yeah,
later. But if you would like to have it done now, I'm willing to commit that time.
I I would I would rather just do it myself.
Okay. So you're not asking for it to be,
Read into the record now.
okay. Thank you. Uh, okay, now we're down to where do we go from here? Um, it did not say yesterday that a specific date was set or being set for this hearing to continue. I did not say, to the best of my recollection, that we could all cancel our reservations for the time that we've allotted for this hearing. I do think that it was reasonable for folks to believe when they left yesterday that the hearing was not going to substantively continue today, at least at the very least. I think it's reasonable for them to believe that. I will reconvene the hearing tomorrow morning. 9 o'clock. And we will continue on, beginning with Mr. Anaker's completion of his cross-examination of Ms. McCulzak. And then we would go to either redirect of her or the city's next witness. So I would appreciate it. I don't believe that I can order this to be done, but I would appreciate it if city staff had email addresses for some or all of the persons who were in attendance yesterday, if they could let those people at a minimum know through an email that we had this short procedural session today, and we're reconvening tomorrow, Thursday the 26th at 9 o'clock to continue on with the hearing. So I'm prepared at this point to recess for the day unless somebody has issues or questions. Ms. Pratt, question or issue?
One other thing the city wants to bring up is we would suggest a tour, a physical tour of the site, where the parties could be present and you could ask questions, and everyone would be there to answer those questions. And we think it would be very helpful. Even this
Okay.
afternoon.
I'm sorry, say again?
Even this afternoon.
Well, I don't know what it's like where you are, but there's somewhat mostly blue sky above Everett. If it's not pouring in Lake Forest Park, I would have no objection going down for a site tour. That's a good suggestion. I appreciate that. Would this afternoon be available?
City's
I'm not
available.
I'm not hearing anybody say no. I'm game for that. I know courts do it. I must admit, I don't think that I have ever been invited in the middle of a hearing to have such a tour as this. So we are breaking a little bit of new ground. And I can see where it might be better because there is a fence out front. And I don't typically, when I'm doing site visits, 40 years ago, I used to traipse around on the property. I loved when I had gravel pit hearings because I could go out in the boonies and 1,000-acre gravel pit. You could spend a lot of time looking at it and seeing what the wetlands really looked like and what have you. And for a variety of reasons, not the least of which some courts have chastised examiners for getting too familiar with a piece of property. Not me, but others have had that experience. I've quit doing that. I don't traipse around on properties anymore. So it's rare that I actually go on a site. I do usually avail myself for either aerial photos, or if I do it in physical, I'm just in the car on the street looking at what I can see and can't see much through the fence with its slats.
Right.
So I would appreciate the opportunity to traipse around. We, unlike a court, don't have a court reporter that we could have traipse along with us and record every question and answer that everybody offers. All I'm going to suggest is that if I happen to be in your presence when you're having a discussion about something, let's keep it as basically factual. Is this or that, or is this or that kind of thing? And if you want to talk about something that bothers you that you'd like to see changed in the project, have me move away.
Yeah, Mr. Hearing Examiner, I understand the impetus for taking taking a site visit, but I am going to have to object. Looking at the rules, 212 discusses a view trip for the hearing examiner, but 212C explicitly says that any in-person view trip will be taken out of the presence of any interested party.
That's fine. We can just open the gate for Mr. Galt. He cannot get in by himself. But I think it would be actually helpful if both sides were there, and if he asked questions, they could be answered, but no other discussion go on between any parties.
My only concern is the fact that there would be no record of the event. And
well, you and I would be there. We could provide the questions and answers
if we needed it.
if we
And
needed
if okay, I think that's a reasonable compromise. And if you're looking for an authority for me to do a site visit where somebody's there, Rule of Procedure 104 paragraph, the second paragraph, it's not numbered, but the second paragraph, talking about how the rules address most normal circumstances, and they give me flexibility, if appropriate, to deviate from them. And I'm going to do that in this case. I do like the suggestion from Ms. Pratt that we essentially don't discuss anything. We may want to introduce ourselves to one another. A lot of you, or at least some of you, I've never met in my life, and I would hate to just wander around with these people and never shake your hand and say, I'm so-and-so. But other than that, we can go without, in the verbal sense of the word, intercourse. And we can just look at what's there and leave. What time do you want to do that? I'm pretty flexible. I am actually, if I had my druthers, I'd rather do it earlier in the day than later, because I'm driving down from Everett. And
Does noon work?
if I come back much after 1 or 2, I hit the nasty traffic coming back north. So if I can,
11:30?
sure, I can be there by 11:30, not a problem. It's about for me, probably about a 40-minute trip, half hour, 40 minutes, depending on traffic.
I think I can be there by 11:30.
Okay, let's do that. For those who want to be there when I do the site visit, we will, where do you want us to meet? Just at the, there's only one parking space at the preserve.
I would suggest we park at City Hall and meet by is that the Chase Bank or just meet in front of City Hall and walk over to the park.
Okay. That works. Meet outside the front door.
Yes.
Okay. That's at 11:30, and then the hearing's reconvening tomorrow at 9. This being a continuance to a date and time certain, there is no requirement for specific notice. I have asked the city, if staff is able to send an email to the folks that they know were involved in this thing yesterday, and advise them that we are reconvening tomorrow to continue the hearing. With that, I will see those of you who want to join the site visit at the front door to City Hall at 11:30. Thank you all very much. Otherwise, we are at recess.
Thank you.